Hi, it's Max Chaudhary, Toronto immigration lawyer. I want to talk about the delays associated with the processing of cases at Canada's Immigration and Citizenship Department. I can start with the ordinary course of events of an application. For example, a citizenship or spousal application or express entry application is filed. A file number is issued. A police check may have been requested and submitted by you, or in the case of a citizenship application, an invitation to write a test is issued and you are successful. But then, nothing happens for many months. The reasons for a delay in processing a case vary, but some sources of delay include a background check. If you are from a less economically developed country, those countries may be slow in issuing police clearances. Other countries require IRCC to directly initiate a step before you can apply for a police clearance, such as Saudi Arabia. Another factor is that you may hail from or may have visited a country run by a pariah government, such as Iran or South Sudan. On a different note, your application may be affected by a third party. For example, a third party may send a poison pen letter, which is received by the Immigration Department or Citizenship Department. This may be, for example, from an ex-spouse who alleges some crime or other legal violation you've committed in Canada or elsewhere, or from a disgruntled acquaintance who alleges you had a fake marriage or fraudulent work history in the past. Another source of delay may be an ongoing investigation of someone else connected to you, like a spouse or other relative that benefited from your visa or other status. Such investigations may be carried out by a third party, such as the CBSA, or an immigration officer in a different department. Consequently, your file may be cross-referenced in that investigation, leading to delays. What possibilities are there to make your application go faster in the face of the above or similar situations? In some circumstances where your application is delayed because of these third parties, you may want to consider the process of Mandamus. The requirements for Mandamus are, generally speaking, connected to the documents presented in the application you have filed. The application must be considered complete. For example, the forms must be complete, the fee must have been paid, and the required third-party documents such as a medical must have been submitted, or at least all of those documents that are within your control to submit to the Immigration or Citizenship Department. What is known as approval in principle, which is a stage of processing, often must have been reached as a prerequisite for a demand letter. This is synonymous with meeting the main requirement of an application, such as a spousal application being determined to have a genuine relationship, or a federal skilled worker application being determined to have the required 67 points. As far as the procedure goes for a demand letter, a formal demand must be made with the office that is tasked with making a decision on your application. The demand must indicate, among other things, that everything required to be submitted by you for your application has been submitted. It also must be asserted that, except for the outstanding issue that you have no control over, the criteria for the visa or status you seek must have been met. There must be an unreasonable delay in the making of the application decision by the Immigration Department. The demand must stipulate a time within which the officer must make a decision, and must indicate that you will ask the federal court to order the Immigration Department to make a decision in the event the application is not resolved. The letter of demand may have one or two outcomes. The outcome of the demand letter should ideally lead to the issuance of a decision on your application by the Immigration or Citizenship Department. If the time frame imposed in the demand letter does not lead to a decision, then it would be required to file an application for Mandamus at the federal court. The time frame for the federal court to decide on the Mandamus application depends on the court's schedule, as well as the response from the lawyer who represents the Immigration Department. It could thus vary from between 2 or 3 months to 10 or 12 months. If you have an application that is taking much longer than normal and are seeking advice about how to make it final and faster, contact Chaudhary Law Office. Thank you.